David Gingerbread Gingras files a motion in the DVRO renewal in the Owens v. Maricini case, saying that Omar is a liar and he is here to defend himself and set the record straight. Let's see what he has to say. First and foremost, this is a public filed document that David Gingras submitted to the courts of the Superior Court of California, County of San Francisco. These are David's words. I am not claiming that what he says is true. This is his side of the story, and we always share the other side of the story when it's available to us. We give it equal time. He files this as an intervener. In the Owens v. Maricini matter, this is the declaration of David S. Gingras in support of his motion to intervene, motion to strike, motion for sanctions, and motion for disciplinary referral to the state bar, assigned to the Honorable Carolyn Gold. The hearing is set for October 21st, 2025 at 8:30 a.m. This is what he is intervening. So he wants to tell his side. He says, my name is David S. Gingras. I am a United States citizen, a resident of the state of Arizona, and I am over the age of 18. And if called to testify in court or other proceeding, I could and would give the following testimony, which is based upon my personal knowledge. I am an attorney licensed to practice law in the state of California since 2002 and Arizona since 2004. I graduated from the University of San Francisco School of Law in May 2000. 2002, 2004. Okay, May 2000, where I was a member of the USF Law Review for 2 years. I am an active member in good standing with the state bars of Arizona and California. I am admitted to practice and in good standing with the United States Courts of Appeal for the 6th, 9th, 10th circuits and the United States District Court for the District of Arizona and the United States District Court for the Northern, Central, and Eastern Districts of California, so not the Southern District. I still would like to know what good standing means. I guess since it's not officially fully on his record as of now, it's considered that. But I don't know that you should be able to say that you're in good standing when you are being investigated. But okay. I previously represented a woman named Laura Owens in a case filed in the Maricopa County Superior Court here in Phoenix, entitled Owens v. Eckerd, case number. I was initially hired by Miss Owens on March 25th, 2024. Shortly after being retained, I learned the case gained a large amount of attention on social media. My belief was the case attached attention in part because a party, respondent Clayton Eckerd, was previously the star of a popular reality TV show, dating show called The Bachelor. In addition, the case also seemed to attract a large amount of attention due to the unusual allegations it involved. Specifically, Mr. Eckerd accused Miss Owens of faking a pregnancy and then using that as leverage to force him into an unwanted romantic relationship. Yep, so far everybody, for the majority, even more than majority, let's say 99% people believe that. My work on Owens v. Eckerd case was primarily limited to presenting legal arguments regarding certain Arizona rules of family law procedure. However, in addition to that work, I also assisted Laura pro bono with responding to inquiries about the case from lawyers, journalists, and others. Yes, she should have had somebody else do that. No wonder. You get what you paid for, Laura. You got shitty, free PR. Hire somebody else next time. One person who inquired about the Owens v. Eckerd case is a lawyer named Omar Serrato. I did not previously know Mr. Serrato, and I first became aware of him on May 23rd, 2024, when Laura forwarded an email Mr. Serrato sent asking questions about the case. Um, my recollection is that Omar did not reach out to Laura. Laura reached out to Omar. Omar had no clue who Laura was or anything about this case when he had made when Laura had contacted him. So you've been lied to by your client once again, or you're remembering wrong. After reviewing Mr. Serrato's questions on May 24th, 2024, I sent him a lengthy email response. I believed my email to Mr. Serrato, which was sent with Laura's permission, was friendly, professional, and otherwise routine. I simply answered Mr. Serrato's questions and asked him to let me know if he needed more information. Okay, with all due respect, Mr. Serrato, it feels weird calling you Mr. Serrato. So, I don't want to call him that. I don't like that. I respect him, but that's not what he's known as. But this is a professional setting, so that's how he is supposed to address him. Continue on. Continuing on with the declaration of David S. Gingras. I later learned that in addition to his law practice, Mr. Serrato has a YouTube channel called The Tilted Lawyer, where he publishes videos commenting on various subjects. While I was not aware of this at the time, apparently Mr. Serrato had published a series of videos harshly attacking and criticizing Laura. Sir, he first gave Laura all the grace that you could possibly give. He corresponded with you. He would have corresponded with her. He wanted to know. So he was giving his opinion on a case at the time that was new to him. Shortly after I sent the email to Mr. Serrato on May 24th, 2024, I was surprised to see a video he had posted discussing my email to him. Mr. Serrato's video was surprising because it was extremely negative, and it contained statements which I believe to be both false and defamatory. Um, okay. I need you to explain more because you don't have proof of anything that he said that was false or defamatory. Among other things, Mr. Serrato told his viewers about my email to him without actually showing the contents of the message. Mr. Serrato insulted me and described my email as extremely unprofessional. Well, I've read an email from you, and it's not professional. Still waiting on you to be a decent guy. because I've offered to fix things on my end, but you're still being a douche canoe. Although this may be an expression of Mr. Serrato's opinion, when viewed in context, I believe Mr. Serrato's video overall presented as intentionally false and misleading discussion of both the issues and of my interactions with him. Where's your cites? Do you cite to anything? You don't have an exhibit for this particular allegation? You don't have receipts, sir. I don't want to hear it. Over the last 20 years, I have handled hundreds of cases in state and federal courts across the country, including many high-profile cases involving major celebrities. Oh my God, sir, you did like basically no work on the celebrity case that you did. And I don't consider Joe Dirt um, to be a celebrity. Uh, Maybe he was, but we're the owner of the JoeDirt.com. We're not talking about David Spade's Joe Dirte. Okay. All right. As a part of practice, I have dealt with significant media attention and inquiries from members of the public, including both journalists and other lawyers like Mr. Serrato. Based on my experience, I know some journalists and commentators act in good faith, trying to present fair and neutral stories for their readers. Okay. I also know that some journalists and commentators do not act in good faith. Well, I have acted in good faith. Many of us have. You act in bad faith. I do everything in good faith. Instead, these people generally are not interested in the truth. They're only interested in crafting a self-serving narrative that they believe will be most attractive to whatever audience they are focused on. That's funny because when you read court documents, it's there in black and white. People can decide for themselves by listening to the court documents or watching a court hearing that they can see and hear with their own eyes. Nobody's feeding them a narrative. We're not up here just telling stories. We are presenting the sides and the motions and everything that the lawyers put forward and their clients put forward. And then you can choose which side to believe. It's real simple. Common sense. I know you lack it. Based on my interactions with Mr. Serrato and my review of several of his videos, I quickly concluded he was not acting in good faith. Is that why you said he was dead to you? And that there was no reason to continue engaging with him regarding Laura's case. No, you didn't like him because he didn't agree with you and see things from your side, because you're one of those people that you cannot agree to disagree and still stay cordial. You have to live in an echo chamber where everybody who does not believe or see things from your side is dumb. And that's just not true. Instead, my impression was that Mr. Serrato was not a serious individual and that he had no regard for the truth or honesty. For that reason, I generally declined my further interactions with him. Well, good for you, sir. Nobody said you needed to interact with him. Regarding Laura's request to renew the DVRO in this case, I obviously understood I was a witness to many of the events on which her renewal request is based. For that reason, I submitted a supporting declaration at the time Laura filed her request to renew the order, but I did not appear as her counsel of record. Mm. Because I am licensed to practice law in both California and Arizona, I know each state has different rules limiting a lawyer's ability to represent a client in a matter where the lawyer may be a necessary witness. In fact, Arizona's ethical rule on that issue, ER 3.7, expressly forbids lawyers from acting in a dual witness advocate role, period, without exception, whereas California's version of Rule 3.7 is more lenient. California expressly permits lawyers to occupy that dual role as long as the client gives informed consent. For that reason, in prior cases, when I have acted as counsel for a party, I have always moved to withdraw from any case where it appeared I may become a necessary witness. Here is just such example from a case called Eccentric Ventures and Mediolex. Okay. So you become a witness often in your cases? Because that's not something that happens very often. In that case, I was initially counsel of record for the plaintiff. However, it eventually became necessary for me to testify as a witness at trial. For that reason, I moved to withdraw from the case. The court granted that request and held my actions were entirely proper under the ethical rules. Well, that's great. Before the court is plaintiff's counsel David Gingras' motion to withdraw with client's consent. This motion, which satisfies the requirements of local rule of civil protection, explains Mr. Gingras never intended to act as both an advocate and a witness at trial, and correctly notes that ethical rule 3.7 would therefore not apply. Accordingly, it is hereby ordered granting Mr. Gingras' motion to withdraw with client's consent. The clerk shall terminate David Gingras as an attorney for record for the plaintiff, dated April 2014. We might look at that case. Interesting. Why did he become a witness? I would like to hear that story. Okay, so Gingras' case is a copyright infringement case, apparently, and they were mad that complaints boards were doing things, and it looks like the people that David Gingras, he was the lawyer for the plaintiff in that case, they didn't end up proving that the other people did anything. Well, they didn't have control over it, about what was posted and things like that. And then even in the appeal, they mentioned that Gingras, where was it at? Dang it. Let's see. Judge says in the appeal that came down, furthermore, it was not clearly erroneous to credit eccentrics only with 10 uses of eccentrics marks in meta tags in the source code of the complaint board website, where David Gingras, eccentric's attorney, testified that he examined the source code of 100 web pages, but he only documented 10. So I don't know why he made himself a witness in that case. I don't know why he seems to make himself involved in a case like that, but apparently he likes becoming a witness. I guess it makes him feel relevant. But moving on. I am aware California's version of professional conduct, Rule 3.7, is far less restrictive than the Arizona equivalent. Specifically in California, a lawyer may ethically represent a client in a matter where the lawyer is also a necessary witness. The only requirement is that the client must give informed and written consent. I don't know if that's the only requirement because judges can say no. In this case, Miss Owens told me that she was willing to provide informed written consent to allow me to represent her while also acting as her counsel. Because she's a dumbass, just like Steve said. However, under this circumstance, I felt the best option was to allow Miss Owens to file the renewal request on her own with my support limited to the role of witness. You're still acting as her attorney behind the scenes. This is not Laura doing this on her own with your support as a witness. No, you're supporting her in her documents and everything else. Because Laura doesn't write things like this. We've seen her pro se filings. So you may not be attorney of record, but don't bullshit us into saying you're not working on things behind the scenes. The situation changed after Mr. Maricini retained Mr. Serrato as his counsel. Prior to this, Miss Owens did not know whether Mr. Maricini intended to challenge the DVR renewal, and thus she did not know whether she was comfortable proceeding pro se or whether she felt the need for help from counsel. Well, that's fine. For an initial appearance, it's fine. After Laura learned that Mr. Maricini had retained Mr. Serrato, she asked me to represent her on a limited basis for the purpose of appearing at the Zoom hearing held in this case on August 15th, 2025. Because that hearing was not substantive and did not involve any written or witness testimony, I agreed to appear remotely on Laura's behalf at that time. Sir, you were trying to clear up the matter in 15 minutes. So don't give me that bullshit. There's some fabrications in here. Several days later, on August 18th, 2025, I had a lengthy phone conversation with Mr. Serrato. According to my phone records, the call lasted 66 minutes. Also present on the call was a lawyer named Rachel Juarez, who has not appeared in this matter, but who I understand is also representing Mr. Maricini in some unknown capacity. Interesting. Yay, Miss Juarez. During this discussion, Mr. Serrato and Miss Juarez told me they believed I should not continue to represent Miss Owens for various reasons. Among other things, they argued I had a present conflict of interest with Miss Owens because last year, Mr. Maricini filed a complaint against me with the State Bar of Arizona, which related to the same events at issue in this case. Mr. Serrato expressed his belief that because Mr. Maricini accused me of misconduct in Arizona, that somehow created a conflict with Miss Owens in this case, which made it impossible for me to represent her. I told Mr. Serrato I strongly disagree with his analysis. Without belaboring the details, I explained to Mr. Serrato that I saw no conflict at all, actual or potential, between myself and Miss Owens with respect to this case. On the contrary, I saw our interest as entirely aligned and consistent, not in conflict. The bottom line is I firmly believe Mr. Maricini broke the law. He committed a crime, and he violated this court's order to such an extent that the relief Laura is seeking in this case is factually and legally proper. This is true regardless of any other allegations about Laura's conduct in any other areas. I do not agree and did not agree that Mr. Maricini's allegations against me, which I perceive as frivolous, have any bearing at all on my ability to represent Laura in this case. In short, Mr. Maricini has accused me of engaging in witness tampering because after I saw him violate this court's DVRO in Arizona, I contacted law enforcement to report what I believed was the commission of a federal crime. You're so full of bullshit. Your documents and your emails say that that is not what was happening. You said, as long as he abides by what I say and has a conversation with me, I won't call the cops. But he didn't, even though he emailed you and didn't have a phone conversation, you still did it. And guess what? Even if you had a phone call with him, you would have still pulled this bullshit. And you may see him as frivolous, but it doesn't look like the state bar sees it that way either. They find it very interesting, and your behavior in this case, very concerning. By retaliating against me with a bar complaint based on my decision to contact law enforcement, I believe Mr. Maricini has committed a further federal act in violation of 18 U.S.C. 1513E, which provides, whoever knowingly with the intent to retaliate takes any action harmful to any person, including interference with lawful employment or livelihood of a person, for providing a law enforcement officer any truthful information relating to the commission or possible commissions of any federal offense, shall be fined under this title or imprisoned not more than 10 years or both. Maricini is not going to fucking jail, you dipshit. He didn't retaliate against you. The way you treated him, even before this, calling the police, was unethical. You tried to blackmail him into getting what you wanted, or helping Owens, in my opinion, try to get Maricini to violate his order by communicating with her. I think you were involved in a setup. I don't have any proof, but that is my belief. 30. For that reason, among many others, I firmly reject Mr. Serrato's argument that it would be unethical or improper for me to continue representing Laura in this matter. Nevertheless, in an abundance of caution, and with the goal of reducing the contentiousness of this case, after discussing the situation with Laura, I decided I would continue to participate in this matter as a supporting witness, but I would not act as Laura's attorney in any capacity regarding this case. Well, you can write her documents for her, and she can submit them as they're her own, but you're not going to be able to argue in court for her. And Lord help whoever does. You know that this is not a good idea. You would be stupid to try this. I called Mr. Serrato to inform him of this decision on August 16th, 2025. According to my phone records that I called, that call lasted 16 minutes. During the call, I told Mr. Serrato that I no longer represented Miss Owens with respect to this case, and I would not appear as a lawyer on her behalf at any future hearings. I also told him that I would continue to participate as a witness, but beyond that, Laura would be representing herself and that he should contact her directly if he had any further questions about the case. Following our telephone discussion on August 21st, 2025, Mr. Serrato sent me an email asking me to confirm in writing that I am no longer representing Laura in this case. Mr. Serrato's message is shown here. So it says Thursday, August 21st, 2025 at 3:39 p.m. that it says, David, do you mind sending a quick email verifying in writing you're not going to represent Laura? 33. I immediately responded to Mr. Serrato's request with an email shown below. He responded at 10:08 p.m. on Thursday, August 21st, 2025. It says, yes, this confirms, as we discussed on the phone today, I am not going to represent Laura any further in the Maricini matters in San Francisco. As we also discussed, despite the single appearance I already did in the Maricini matter, my notice of appearance was somehow rejected by the court for technical reasons. Thus, the docket does not show me as Laura's counsel of record. Because I am not counsel of record, I do not believe I need to formally withdraw since I have not yet formally appeared. How do you get technically rejected on a notice of appearance? That's bizarre to me. I've never heard of that. Look further into that as well. Finally, I also told you that while you don't need my permission, you can contact Laura directly as needed moving forward since the docket continues to show Laura has other counsel of record. You may want to contact them to clarify their position. David Gingras. Okay. Unfortunately, although I believed I sent the email to Mr. Serrato shown above, dated August 21st, 2025, the next morning I saw an email to Mr. Serrato appeared to still be open and unsent on my desktop. Although the email does not appear in my sent message folder along with all the other outgoing emails, based on this, it was not clear that the message was sent or delivered, so the following morning I sent a shorter second email shown below, which confirmed I no longer represent Laura in the Maricini matter. Okay, so he sent and then Omar on Friday the 22nd at 7:58, so 4 minutes after Gingras sent that, Omar said, thanks, David. Okay, so that's funny. You can make mistakes on email, but I can't. You're such a stand-up hypocrite. Based on the events, I was shocked when I learned that on August 25th, 2025, Mr. Serrato filed a motion to disqualify me from acting as Laura's counsel in this case. One of the many reasons I decided not to continue representing Miss Owens was to avoid even the mere appearance of impropriety. Even though I believed Mr. Serrato's conflict of interest arguments were specious. And specious, if you don't know, is something that appears superficially or deceptively, lacks real merit, truth, or substance. So that's a dig to Omar in the legal writing. I also did not want to burden this court with needless motion practice over the propriety of my participation. The simple fact is that regardless of whether I acted as Laura's counsel of record, I am still a recipient witness in this case. Thus, even If Laura represents herself without counsel, I can and will tell this court what I saw and will testify about the events leading up to this point. For that reason, I did not think remaining as Laura's counsel of record was sufficiently important to justify challenging Mr. Serrato's position, even though I disagreed with it. Well, you disagree with a lot of things, and mm, your decision making doesn't have a good track record. You might just be the star witness, Gingras. You might just be. Also, why is it shocking that somebody would want to make sure that this doesn't happen? Because you say you're not going to do something and then you do it. So, pardon Omar for not believing you. He doesn't trust you or Laura at all. It's clear to me that Mr. Serrato intentionally lied to this court about the facts and has attempted to actively mislead the court about the truth. This conclusion is based on, among other things, the extremely careful wording shown below, where Mr. Serrato claims that I told him, both verbally and in writing, that I do not intend to represent Laura Owens in these proceedings. So here's the snippet from that. Omar put, a hearing was held on August 15th, 2025, where attorney David Gingras appeared for petitioner Laura Owens at the hearing on August 15th, 2025. David Gingras has since indicated to counsel Omar Serrato, both verbally and in writing, that he does not intend to represent Laura Owens in these proceedings. How is that a lie? You told him on the phone you didn't intend to. You weren't going to. No, you're not representing her. You also told him in writing in the email you do not intend to represent her. You're not representing her, basically. So, why is that considered a lie? Why is that a lie? You did tell him that. I believe Mr. Serrato used this line to make it appear that he did not completely lie to the court. After all, he kind of mentions the written and verbal discussions between counsel, which is good. But rather than telling the court that I actually said that I no longer represent Laura in this case, Mr. Serrato changed the quote to make it appear far more uncertain and unequivocal. That's how you took it. Just because you read it that way doesn't mean that Omar lied. Your emails say, I don't intend to. I do not. Good God, if this is what you constitute as a huge lie, this is the lie that you were prepping everybody for, is that Omar said does not intend to represent Laura Owens, but you said I no longer represent Laura. Okay. Like, okay, you're nitpicking words here. That is not Omar lying. Example, Miss Serrato avowed that I am continuing to represent Miss Owens in this case, and I have somehow refused to clarify that the attorney-client relationship has actually been terminated. He did not say that. He did not say that you were continuing to represent her. He was saying you appeared, and now you say you do not intend on representing her. He didn't say anything about that. That's you making shit up. You lying. Because where's your proof that he said that you are continuing to represent her? He didn't say that. He wants to make sure that you aren't going to be able to. Because while you may say you're not going to, Omar wants it on record that no, this guy is not representing her. He is a witness, and that is it. And in my opinion, I don't think that your attorney client relationship has actually been terminated. That's my opinion. You're just not there in court helping her. You're just in the background. Based on my past dealings with Mr. Serrato, I have no question that he intentionally gave this court a false and misleading impression of what occurred, and that he did so for the specific purpose of filing a pleading that contains serious allegations of misconduct on my part, which Mr. Serrato knew were entirely false. What false and misleading impression did he give by saying that you do not intend to represent Laura? And you told him that in writing and verbally, and that this motion is expected to be unopposed by Laura because that is the agreement that y'all had. That is not misleading the court. That's not lying to the court. I am also confident that Mr. Serrato did this for one purpose: to give his YouTube friends fodder to create additional videos attacking me exactly as Mr. Serrato has done over and over and over during the past year. Oh, are you feeling hurt, baby Jingy? According to YouTube, Mr. Serrato has posted more than 400 videos on his channel here. You know what most of those videos are? After dark. Many of his videos is after dark, Reddit stories, and some other stuff. Most of his videos are not about Laura Owens or you. Recently, there has been videos about you until he took on this case and became Maricini's lawyer. Okay. Mm-mm. Although certainly not all of these videos are focused on myself or Laura, a large number of them are. And virtually everyone is insulting, disparaging, and in many cases, defamatory. No. In many instances, Mr. Serrato insults my unusual French Canadian surname. Okay, he didn't start that. Referring to me as Dingus, Jingy, Gingerbread, and often douchebag or douche canoe. That is not defamatory. That is called satire. Like, we don't like you, we're allowed to call you a name. He was, at this point, not a lawyer involved in this case. Like he was just an outsider. He was not in this case in a professional capacity. This was free time, non lawyer him. I mean, he's still a lawyer, but this is not him. He was not acting as a lawyer for any of the parties. So he was just an outside party commenting on a case. People are allowed to do that. It happens every day on YouTube. In these monetized videos, Mr. Serrato frequently steals photographs of me from social media pages and uses them without my permission as a part of his video thumbnails. Just a few examples are shown below. Oh, here he is with his copyright things. Gingras complaint. David Gingras' complaint against Judge Mata dismissed. Did he lie? 6 months ago with 1.3 thousand views. Gingerbread submits appeal to Arizona Supreme Court. Mouths on, I guess. Gingras doesn't want our invitation. He doesn't want the smoke. Why do you not appreciate any of our humor, sir? In addition to personally insult and attack me, Mr. Serrato also frequently publishes scathing, exceptionally cruel personal attacks against Laura, often portraying her as being physically assaulted by Mr. Eckerd. What? In addition to personally insulting and attacking me, Mr. Serrato also frequently publishes scathing, exceptionally cruel personal attacks against Laura, often portraying her as being physically assaulted by Mr. Eckerd. Omar has never said that Clayton has hit her. Or that Eckerd personally physically assaulted Laura. Your sentence doesn't make sense, and it's also a lie. I don't know if that's what you meant to type, or if you meant it the other way around, but that's a straight lie and not a factual statement. Nobody says that. Mr. Serrato also frequently uses cruel, humiliating images of Laura crying, juxtaposed with the smiling faces of his friends, taking pleasure in Laura's pain. The only pain she has dealt with is the pain that she has caused herself. Owens v. Eckerd, Clayton Eckerd versus Jane Doe. The gloves are off. Round 2, ding ding. And there's disgusting false accusations. Yeah. In my nearly 25 years of practice, I have worked on a large number of major important cases in both state and federal court, many of which were extremely contentious. I have litigated cases before the California Court of Appeals as well as appearing on behalf of an amicus curiae before the California Supreme Court. I have obtained multiple favorable published decisions from the state and federal trial and appellate courts across the country. Based on my experience handling a large amount of contentious litigation, I am used to seeing rude, disrespectful, and unprofessional conduct by opposing counsel. This is thankfully rare, but it is something I have dealt with many a times over the years. Mr. Serrato's conduct, as described above, is markedly different. First of all, he wasn't a lawyer against Laura Owens when he posted this. He was not involved in any of her cases. You know what he hasn't done since he has been a lawyer in opposition to Owens? He hasn't posted a single thing about this case. Because it is different when you're a lawyer on a case and when you're a lawyer and it's not your case. Surprise, surprise. Mr. Serrato's actions are not merely unprofessional. They are cruel, malicious, threatening, and personally vicious to a degree. I have never seen from any lawyer in any case anywhere in this country. Well, then you apparently aren't on the internet as much as you say you are. Pursuant to 28 U.S.C. 1746, I declare under the penalty of perjury, under the laws of the United States of America and the state of Arizona, that the foregoing is true and correct. Dated September 12th, 2025. Signed, Gingras, Intervenor. Uh, okay, I don't remember if he asked for sanctions on here. Maybe he did in the beginning and I'm not remembering. Because, and wanting him to be reported to the state bar for his conduct. Like that was it, like in the statement, but I don't know that he really addressed that as to why. And the huge lie that he's saying that Omar has created is not a lie. He's just, oh my God. David, you were supposed to have some like bombshells in this. There was no bombshells in here. None. You were supposed to show how Omar is somebody that we shouldn't trust and he's just a liar, liar, pants on fire. But you've shown me nothing. There's nothing here. So you have disappointed people once again. Why we expect anything better is beyond me. But I'm sure you're used to being a disappointment in everybody's life that you encounter. Ending this video with our quote of the day. Accept responsibility for your life. Know that it is you who will get you where you want to go, no one else. Gingras, accept responsibility for your life. Tell your client she needs to take some responsibility. And until you do accept responsibility in your life, you are not going to go where you want to go. Things are not going to end the way you want them to end. But you are the one who is in control of that. Own your shit. Take responsibility, some accountability, and start moving in the right direction. Because this is surely not where the two of you wanted to end up. But you're here. And until y'all take some ownership, you're not leaving here. This is your downfall. And I don't know if for Owens, If she gets convicted and gets jail time, if there is a more rock bottom, and it is all because she cannot accept responsibility for her life and why it is the way it is. I don't know what it's going to take for you. I don't know where your rock bottom is. You're not there yet, but keep continuing on this path and you will hit it. That is going to be it for me, and I will see you guys very shortly for another video. Bye.